Greetings, Attorney Derek DeBrosse, Munitions Group, munitionsgroup.com, coming to you from Dublin, Ohio. I'm coming to you today with a piece of current events that just popped across my desk in the last few days. There was a district court judge in a district in Florida that heard a case, or ruled on a case rather, that was challenging in a criminal case that was challenging the constitutionality of the United States Postal Service's prohibition on firearms on property. This was a case where a gentleman who worked for the post office had a concealed carry permit and I believe was found with a firearm on him on postal grounds, challenged this. So this district court judge dismissed those charges under the guise of the Bruin decision and on the constitutionality of that prohibition. I wanted to do a quick video on this because this actually has come up before and has gotten pretty far in the judicial system, actually having the U.S. Supreme Court deny cert, but in a pretty thorough decision of denying cert. It was about 20 pages, which is not necessarily unusual, but it's not, I would say, the everyday denial. That case was, let's start with that case. That case was Tab Bonity versus United States Postal Service, and I believe it was a civil case. Mr. Bonity had sued in Avon, Colorado, where his post office was at. They were enforcing this prohibition, of course, that said no firearms in our building or on our parking lots. He had sued, and it worked its way up through the system. The 10th Circuit basically said, yes, this is constitutional, and then it was appealed, and the U.S. Supreme Court denied to hear the case on what's called a petition for certiorari, which is essentially a request saying, U.S. Supreme Court, please take this case. We believe that there's some constitutional defects in the lower court's decision. The court did a pretty thorough analysis and basically said there's nothing to indicate that this is unconstitutional. Now, what you need to remember, this is pre-Bruin, which is what the district court judge in Florida applied. And in fact, through that litigation back in, I think the case of the Bonity case was in 2014 around that time, a lot of courts were still hashing out, is this going to be a strict scrutiny or an intermediate scrutiny standard of review, meaning when we look at a gun regulation, we apply a certain standard to determine if it's constitutional or not. And the different scrutinies are basically an interest balancing between the government's interest and the private libertarian interest of somebody's civil liberties. Now, if you go back to the Heller decision in 2008, Scalia, in my opinion, made it fairly clear that interest balancing is not to apply to the Second Amendment. I actually had argued that in a Sixth Circuit case that we got a dissent on, but ultimately lost 2-1. But I argued that. And in that case, even my dissent said strict scrutiny should apply, and I didn't argue any of these. I actually said in my motion none of these should apply. So I felt vindicated when Bruin came out. But I digress. So keep that in mind. In the Bonity case, we're dealing with pre-Bruin jurisprudence. Now we have the Bruin case, which says we apply a historical tradition analysis when we look at the standard as to whether or not a gun regulation is constitutional under the Second Amendment. Was it in line with the historical traditions of the time when the Second Amendment was ratified? And so this judge, I'm going to quote you something that she said in her decision, quote, a blanket restriction on firearms possession in post offices is incongruent with the American tradition of firearms regulation. She further elaborated, according to this article, the government didn't meet their burden of proof, to uphold the prohibition, and she highlighted that post office, although part of American life since its founding, there's no historical regulation. Again, bringing into that Bruin analysis, no historical regulation dating back to that time to justify a sweeping ban in post offices. And in fact, I don't think there was a ban on firearms in post offices until the 60s, actually. So that is what the judge says. So at least in that judge's district right now, it appears that that's going to be some binding law. I'm sure it'll be appealed, but I wanted you guys to have context of that if you heard this come across the news wire. So real interesting stuff, so stay tuned. And as always, be safe and carry on.